You're listening to the North Star Law Firm podcast. Clear, practical analysis of tax and bankruptcy matters that affect business owners and individuals. Each episode breaks down a current legal development and explains what it actually means for the people who have to deal with it. Brought to you by North Star Law Firm in Houston, Texas. Here's today's topic.
It is July 2026, and for well over 1 million small businesses right now, this massive, invisible financial shield just kind of vanished.
Yeah, it really did. Overnight, almost.
Right. So the temporary protections that basically kept all those pandemic-era disaster loans out of the federal government's, primary collection machinery, those have officially expired. So welcome to today's deep dive.
Glad to be here. There's a lot to cover.
There really is. And whether you're a business owner catching up on the financial landscape or you're just insanely curious about how the economy actually ticks behind the scenes, we've got something pretty good for you today.
Absolutely. The stakes are just astronomical right now.
Yeah, exactly. So today we are pulling from this plain language grounding document that was prepared for North Star Law Firm. It's basically this internal brief specifically decoding SBA loan defaults and EIDL debt resolution. And we are talking about millions of default letters going out right now. That's tens of billions of dollars.
The scale of this event is just, it's unprecedented in modern federal finance. For several years, business owners who fell behind on these specific pandemic-era loans, they had breathing room,
Right, the government just kind of hit pause.
Exactly. They hit the pause button on their most aggressive collection tools, and there was this dedicated hardship program to keep payments low. But that grace period, it's over. The hardship programs for already ended loans are entirely done.
So these defaulted loans are just getting shoved into the standard federal collection process.
Yes, a highly aggressive standard federal collection process. But our goal today is to cut through the panic because a default notice is really just the start of a mechanical process. It's not a final judgment.
Okay, let's unpack this. Because to understand the panic that's setting in right now, we first have to understand that, not all SBA debt is created equal. Knowing what kind of debt you have dictates your entire survival strategy.
That is the foundation of everything we're talking about today.
Right. So think of a traditional SBA loan like buying a house with a very wealthy cosigner like the government. But these pandemic disaster loans, that is like getting a loan directly from the central bank itself.
Yeah, and that distinction changes everything. Traditional small business loans, so the ones you use for daily working capital, buying heavy equipment, acquiring a franchise, those are actually issued by regular commercial banks.
The bank is the one actually giving you the money.
Exactly. The SBA simply guarantees a portion of that loan. And because a private bank is putting its own capital on the line first, they demand, really traditional, rigorous underwriting.
Right, which means they want some skin in the game from you.
Oh, universally. It almost always requires a personal guarantee from the business owner, and usually a direct lien on business assets or even the owner's personal real estate. But pandemic disaster loans bypass the banks entirely.
The government just became the direct lender.
Right. The federal government acted as the direct lender, and because they were trying to pump money into the economy so quickly during a crisis, they completely bypassed traditional underwriting.
Which created this massive vulnerability for them, but also kind of a strange layer of protection for the borrower, right? Depending on the size of the loan. The brief highlights this magic number, which is $200,000.
Yes. For pandemic disaster loans specifically, that $200,000 threshold dictates your personal exposure. Because they were moving so fast during the crisis, for loans at or below $200,000, the SBA generally did not require a personal guarantee.
Wait, so the debt just belongs to the business, like the LLC?
Entirely to the business entity, the LLC or the corporation. If the business fails and the loan was under that threshold, the individual owner is generally not personally liable to pay it back out of their own pocket.
Okay, wow. But the moment you crossed that line, everything changed. Like if a business borrowed $250,000, the government required the owner to pierce their own corporate veil and sign that personal guarantee.
Exactly. So if the business goes under in that scenario, the government looks directly at the owner's personal bank accounts.
So you could literally have two businesses side by side on Main Street that both failed. The one that borrowed 150 grand faces like minimal personal exposure, but the one that borrowed 500 grand is looking at devastating personal liability.
That's the reality of it. The honest answer to the question, how much trouble am I in, is found exclusively in the original loan paperwork, not in all these panic-inducing headlines online.
Right, you have to verify which bucket your loan falls into.
Precisely, because the actual mechanics of the collection process change depending on who really owes the money.
Okay, here's where it gets really interesting. Because if you are dealing directly with the entity that, prints the money and writes the laws, they don't have to play by normal banking rules. I think the common fear keeping people awake at 3 a.m. right now is this idea of guys in suits showing up to seize their house.
Right, the classic movie scene.
Yeah, exactly. But the government doesn't need to sue you because they basically control the financial plumbing.
And that's exactly what all this alarmist debt relief marketing relies on, right? The threat of a massive courtroom battle or an immediate foreclosure. But the reality of federal debt collection is far more mechanical and honestly a lot quieter.
Quieter, how so?
Well, the government isn't filing mass lawsuits in federal court against a million ordinary borrowers who simply couldn't pay. They don't have the manpower for that. And more importantly, they don't need to. They use something called administrative collection.
Administrative collection, meaning they just kind of reach into the system and take what they're owed without ever seeing a judge. The brief mentions the Treasury Offset program. How does that actually function for, a listener who might be in the crosshairs right now?
Think of it as a completely automated dragnet. The Treasury Offset Program, or TOP, is this massive centralized database. When an SBA loan goes into default and is transferred to the Treasury, your taxpayer identification number or your Social Security number gets flagged in that system.
Oh, wow. So they just flag your ID.
Yeah, and from that moment on, any federal money that was meant for you is just intercepted.
Yeah.
They seize your tax refunds automatically. They offset certain federal benefit payments.
It's automatically grabbed before it hits your bank account.
Exactly. And furthermore, through administrative wage garnishment, they can direct your employer to withhold a set percentage of your take-home pay and send it straight to the government. This all happens entirely outside of the judicial system.
That is, the math on the penalty for entering this phase completely changes the risk calculus, too. I saw a 30% figure in the brief. How is a penalty that massive legally justified without a judge even signing off on it?
It functions as an administrative fee to fund the collection apparatus itself.
You're paying for them to collect from you.
Basically, yeah. When the debt leaves the SBA and goes to the Treasury, or if it gets outsourced to private collection contractors, those entities are allowed by statute to tack their operational costs directly onto your balance.
That's rough.
It is. It's a substantial penalty, often around 30%. And it's added simply because the debt was referred for collection. So a defaulted $100,000 loan can balloon to $130,000 almost overnight.
That is a staggering financial blow.
Yeah.
But the brief also makes it pretty clear that we need to balance this mechanical reality with some clear-headed truth to calm the panic. Taking someone's home, for example, is a totally different and much higher bar than, intercepting a tax refund.
Absolutely. Seizing real estate is not an administrative action. You can't just press a button for that.
Right, but you need a judge for that.
Exactly. To foreclose on a home or a commercial building, the government generally requires either a pre-existing lien on that specific property, or they have to go through the whole effort of securing a formal court judgment.
So they can't just take your house over a smaller unsecured loan.
No, they cannot administratively seize your house simply because your LLC defaulted on a smaller unsecured pandemic loan. And understanding that realistic threat level is what prevents panic, because panic leads to paralysis, or worse, just making terrible financial decisions in the dark.
For sure, but if the government doesn't even need a judge to take 30% of your paycheck, you can't exactly fight them in a standard civil court. You have to use a tool that outranks administrative collection.
Which brings us to the escape hatches, specifically federal bankruptcy law.
Yes, the heavy machinery.
Right. And I think a common misconception is that you simply cannot bankrupt government debt, sort of like the rules around most student loans. It is a really pervasive myth. People tend to group all federal debt into one big, indestructible category. But an SBA loan is classified as an ordinary commercial debt.
So it's not specially protected.
Not at all. It is not shielded by the special exemptions that protect student loans or, certain tax obligations. Personal responsibility for an SBA loan, even if you signed a personal guarantee, can absolutely be discharged in a federal bankruptcy.
Wow, okay. And the relief from that administrative dragnet we just talked about is immediate, right? The brief outlines the mechanics of something called the automatic stay.
Yeah, the automatic stay is arguably the most powerful injunction in civil law.
Really? The most powerful?
It's definitely up there. The exact second a bankruptcy petition is filed and time-stamped by the court, a federal legal shield just drops into place. It instantly halts the Treasury Offset program. It stops administrative wage garnishments dead in their tracks.
It just cuts the wires on the whole machine.
Exactly. It stops the collection calls, prevents any further asset seizures. It freezes the entire collection machine and forces the government to deal with you inside the structured rules of the bankruptcy court.
Which actually gives a business owner the space to breathe and, formulate a strategy. And bankruptcy isn't just a one-size-fits-all hammer. The brief outlines 3 distinct federal paths here. And the mechanics of the small business reorganization, I think it's known as Subchapter V, are fascinating.
Yeah.
It's not just handing over the keys and walking away, right?
Right. The paths are really tailored to the viability of the business. So the first path is a standard Chapter 7 straight liquidation.
Which is the walking away part.
Right. If a business is dead in the water, this is designed to quickly marshal any remaining assets, sell them off, distribute the pennies to creditors, and legally wipe out the owner's personal liabilities so they can just move on with their life.
Okay, but what if the business is still kind of surviving?
That's the second path. The small business reorganization under Chapter 11, Subchapter V. It's designed for a business that is fundamentally sound, but is just being crushed by a specific mountain of debt.
How does that actually restructure the debt without liquidating the company? Do they just negotiate it down?
The mechanism is what bankruptcy professionals call a cram down.
A cram down. I love that term.
It's very descriptive. Basically, the business owner proposes a structured plan to pay creditors a portion of what is owed out of the company's projected disposable income over, say, a period of 3 to 5 years.
Okay, so it's a payment plan based on what they can actually afford.
Right. And the court prioritizes secured debts like a mortgage on a building. But an unsecured SBA loan just gets lumped in with all the other general unsecured claims.
Oh, wow. So the government just has to take a back seat.
Pretty much. The court can approve this reorganization plan even if the SBA objects to it. It allows a viable business to shed the dead weight and survive.
That's huge.
Yeah.
And then you have the third path, right? The Chapter 13 individual repayment plan, which operates on a similar logic, but for personal income.
Exactly. It's a court-supervised restructuring of an individual's debts over several years, which protects their personal assets from liquidation.
So those are the heavy-duty legal tools.
Right.
They require federal court intervention, but they provide absolute finality.
Yes, complete finality.
Okay, but what about the non-court option? The offering compromise? Because you see the commercials all the time. Settle your debt for pennies on the dollar without bankruptcy. The SBA must have a mechanism for this, right?
The SBA does have an offering compromise program, yes, but relying on it for these specific pandemic loans right now is incredibly risky.
Risky how? Are they just denying them?
The standards are just incredibly rigorous. First, the agency generally requires that the business be permanently closed and completely liquidated before they will even entertain an offer.
Wait, really? You have to kill the business first?
Yes. And on top of that, you have to prove a genuine math-based inability to pay in full. And your settlement offer has to equal or exceed what the government could reasonably expect to recover through forced administrative collection anyway.
Ah, I see. So if you have significant equity in your home or a massive retirement account, the government isn't going to settle for 50 grand just because you want a discount. They know they can collect more by just turning the screws.
Exactly. And furthermore, the sheer volume of these defaults has just overwhelmed the system.
Over 1 million businesses, right?
Right. The SBA simply does not have the underwriting manpower to individually evaluate and negotiate 1 million complex settlement offers. Because of this, very few offers in compromise for pandemic disaster loans have actually been approved to date.
So they're just defaulting to the automated stuff.
Exactly. The agency is relying heavily on the automated hammers of the Treasury Offset program instead. Treating a settlement as a guaranteed escape hatch is a really dangerous strategic error right now.
And this brings up a critical trap outlined in the brief. Say I'm a listener and I've been through a rough patch before, right? I settled a tax debt with the IRS a decade ago. using an offer and compromise. I might assume I could just use that exact same playbook here, right? I mean, it's all federal debt.
Applying IRS logic to an SBA loan is fatal. That is a major, major trap.
Fatal. Why?
Because while both agencies use the exact same term, offer and compromise, they're governed by entirely different federal statutes, and they operate under completely different sets of rules.
So they're looking at different things.
Yes. The IRS is primarily evaluating your future income potential. The SBA is evaluating commercial lending standards and collateral recovery.
Ah, so they're looking at your assets.
Right. So advice forms or legal strategies that worked for a tax issue absolutely do not transfer to an SBA commercial loan default.
Okay, so applying IRS logic is trap number one. But the brief highlights a massive blind spot regarding property that seems, honestly, even more dangerous. I imagine a lot of people think if a bankruptcy judge wipes away their personal guarantee, their real estate is suddenly free and clear too. Wiping out the personal liability doesn't magically vaporize the lien on a building, does it?
No, it does not. And misunderstanding this nuance literally ruins lives. A lien is a secured property interest. In legal terms, there is in personam liability, which is your personal obligation to pay a debt, and in rem liability, which is the claim against the physical property itself.
Okay, so the debt is attached to you, but the lien is attached to the house.
Exactly. Bankruptcy is incredibly effective at wiping out the in personam liability, so the government can no longer garnish your wages or seize your bank accounts. However, the in rem liability, the lien attached to your commercial building or your home, that generally survives the bankruptcy completely intact.
So like 5 years down the line, you go to sell that property thinking you are entirely clear of the pandemic debt, and the government just steps in at closing to take their massive cut from the sale proceeds.
That happens all the time. Before choosing any resolution strategy, determining whether a lien has legally attached to your real property is the threshold question.
You have to know what they actually have a claim on.
Right. Because if you file for a liquidation bankruptcy operating under the assumption that it will clear the title to your house, and it doesn't, you have just surrendered your assets for incomplete relief.
That's terrifying.
And if we connect this to the bigger picture, timing dictates absolutely everything about how these tools can be deployed. An SBA demand letter isn't just a threat, it's a timer.
A timer, like a literal countdown clock.
Basically. A borrower typically has a 60-day window from the date of the initial demand letter to respond before the debt is officially transferred out of the SBA and into the Treasury's collection apparatus.
So you get the letter, the clock starts ticking. And as that clock runs, your menu of options actually shrinks.
Rapidly. While the debt is still with the SBA during that 60-day window, you have the maximum leverage to negotiate a workout, maybe submit an offer in compromise, or structure a repayment plan.
But after 60 days,
once the debt is referred to the Treasury Offset program, those early administrative options just vanish. And if the Treasury then forwards the debt to an outside private collection contractor, the options narrow even further.
because the private guys don't have the authority to make deals.
Exactly. Private contractors have virtually no authority to approve complex settlements or restructure collateral. Their only mandate is simply to collect the balance plus their hefty fee.
So what does this all mean for someone navigating this maze right now? If a listener pulls one of these demand letters out of their mailbox today, the brief has a glaring warning about what not to do. Do not ignore the mail, obviously.
Obviously.
But more importantly, do not sell or move anything that might be pledged as collateral.
This is critical. When you sign the original loan documents, particularly for loans over a certain size, you likely pledge the general assets of the business as collateral.
What does that include?
That includes inventory, heavy equipment, accounts receivable. If you receive a demand letter and panic, say you start selling off equipment for cash to pay rent, or you try transferring assets to a newly formed LLC to hide them from the government.
People do that, right? Thinking they're being clever.
They do, but you aren't executing a clever legal maneuver. You are stepping on a landmine. You are actively converting a standard civil debt problem into a criminal fraud allegation.
Criminal fraud.
Yes. The federal government views the unauthorized transfer of pledged collateral as a deliberate act to defraud a secured creditor. You violate federal statutes the exact moment you try to hide their collateral.
So you really need a forensic read on your actual exposure, which requires reading the original documents, not just reacting to the scary collection letter.
Yes, and this raises an important question. Who do you actually call for help? Because resolving this requires an intersection of skills that, frankly, a standard local attorney might not possess.
Right, because it's not just a standard lawsuit.
Exactly. You need a deep understanding of federal administrative law, federal bankruptcy codes, and complex corporate accounting.
And that's where the source of our information today comes in.
Yeah.
North Star Law Firm is a Houston-based practice.
Managing a massive SBA default is fundamentally a federal financial puzzle.
Because of all the numbers involved.
Right. You cannot just apply legal statutes. You have to trace asset depreciation schedules. You have to analyze commercial balance sheets to prove a genuine inability to pay if you're trying for a settlement offer.
Which a regular lawyer might not know how to do.
Usually not. North Star Law Firm combines bankruptcy litigation experience in the Houston federal courts with the deep CPA accounting background required to dissect a really complex commercial loan file. They help business owners map out the exact location of their collateral, assess their true personal exposure, and then execute a strategy before that 60-day clock expires.
Right. You have to choose the resolution that actually fits the mechanics of your specific loan. Like,
Yep.
Are you under the $200,000 threshold? Do you have an active lien on your real estate? Do you need a Chapter 11 cram down to keep the doors open, or a Chapter 7 to just walk away clean? It is a very complex maze, but it is a navigable one, right? If you don't wait for the options to be taken away from you.
It's all about proactive timing.
Well, we've covered incredible ground today. For everyone listening, the end of the 2026 pandemic grace period is, it's undeniably daunting if you're holding one of these defaulted loans, the safety net is gone, and the federal collection machine is just wide awake.
It's firing on all cylinders.
Yeah. But understanding the mechanics, knowing why that $200,000 threshold exists, understanding how the Treasury Offset program funds its 30% penalty, recognizing that wiping out personal liability in bankruptcy doesn't just magically erase a property land, and respecting that 60-day window, that knowledge returns the power to you, the borrower.
You don't have to be a victim of the automated dragnet.
Exactly. You have federal legal pathways to restructure or wipe the slate clean, provided you take calculated action before the clock runs out. But as we wrap up, I really want to leave you, our listener, with something to think about. We've spent this deep dive mapping out the survival mechanics for individual business owners, right? The tactics, the traps, the escape hatches.
The nuts and bolts.
Yeah, the nuts and bolts. But zoom out for a second. We're watching well over 1 million businesses default, and the federal government is acting as the direct, aggressive collection agency for tens of billions of dollars right on Main Street.
It's a massive shift.
It really is.
Yeah.
How will this mass administrative collection event fundamentally reshape the relationship between the American small business owner and the federal government for the next generation? When the entity you turn to for capital during a crisis becomes the exact same entity directly garnishing your wages and intercepting your tax refunds a few years later, that leaves a lasting psychological scar. It absolutely does. How does that change the willingness of entrepreneurs to partner with the government the next time the economy falters? The financial floodwaters of the pandemic are finally receding, and we're only now seeing the permanent changes to the landscape that they left behind. So keep exploring, stay curious, and if you're in the thick of it, whatever you do, do not ignore the mail. We'll catch you on the next deep dive.
Thanks for listening to the North Star Law Firm podcast. This podcast is produced for general educational and informational purposes only and should not be construed as tax, legal, financial, or accounting advice for any specific situation. Listening to this podcast does not create an attorney-client or CPA-client relationship with North Star Law Firm. Tax and legal outcomes depend on the specific facts of each matter and on applicable state and federal law, which varies by jurisdiction. If you have a matter that requires professional advice, consult a qualified attorney or CPA licensed in your jurisdiction. For further inquiries or to start a conversation, visit us at htx-legal.net. Copyright 2026 North Star Law Firm. All rights reserved.